Supreme Court of India Suresh Garodia versus State of Assam, and another decided on January 9, 2024 SCC Online SC 38 Facts of the case. The prosecutrix lodged a fire before the alleging therein that when she was 15 years of age, the appellant herein committed rape on her, and as a result of which she gave birth to a child. Magistrate, after considering the said final report, rejected the same and directed that the cognizance be taken on the basis of the police report. Being aggrieved thereby, the appellant filed a petition under Section 482 crpc before the High Court, which was rejected. Findings of the court: the statement of the prosecutrix as well as her son were recorded. In the statement, the son of the prosecutrix even admitted that the appellant herein was providing cash money and other facilities to him as his son. The final report states that only on account of greed for property of the appellant Suresh Garodia, the prosecutrix, in connivance with her son, has filed the fire after a period of 34 years. The investigating officer opened that the case was of a civil nature, and therefore the appellant herein should be discharged from the said case. No doubt that the learned magistrate, while exercising his powers under Section 190 crpc, is not bound to accept the final report of the investigating officer. However, if the learned magistrate disagrees with the finding of the investigating officer, the least that is expected of him is to give reasons as to why he disagrees with such a report, and as to why he finds it necessary to take cognizance despite the negative report submitted by the investigating officer. Nothing of that sort has been done by the learned magistrate in his order dated 4th July 2017. We find that lodging a case after 34 years, and that too on the basis of a bald statement that the prosecutrix was a minor at the time of commission of offense, could itself be a ground to quash the proceedings. No explanation whatsoever is given in the fire as to why the prosecutrix was keeping silent for a long period of 34 years. The material on record shows that the relationship was consensual, inasmuch as the son who was born out of the said relationship has been treated by the appellant as his son, and all the facilities, including cash money, have been provided to him. The continuation of the proceedings would lead to nothing else but an abuse of process of law. The impugned order passed by the High Court and the order of the learned magistrate dated 4th July 2017 are hereby quashed and set aside, and the present appeal is allowed.